Today's discussion is going to be about what the judgment means for every citizen in this country. And joining us here is Indian Economist Reetika Khera, who will be explaining the things to us. Reetika, first of all, I want to thank you for doing this for us. So I would like to begin with the first question. If you can explain to us in a nutshell what the judgment is all about and in perhaps like 2 or 3 sentences what it means for the country.
Okay. So I think it, like you described it, it is in fact a historic judgment, and of course we're very happy that it's turned out the way it has. Although we were quite nervous, then in the run-up to the judgment, we shouldn't have been. I mean, we are in the 21st century. We are a democracy, so in a country like this, it would have made no sense to have any other judgment than this. And yet, given the times that we are in, not just in this country but also elsewhere, there was a little bit of sense of nervousness and apprehension that this should turn out right. So what the court has done is basically just reaffirmed its earlier position. Even though the government was contesting the Supreme Court's earlier position on whether the right to privacy is a fundamental right or not.
Okay, so could you please tell us what are the 3 major advances the judgment brings?
Right. Let me just give you a little bit of background to how we got here. The whole matter became primarily a discussion about the right to privacy in the Aadhaar case. There were several petitions in the Supreme Court from 2013 onwards, early 2013 onwards. And when it came to 2015 and Justice Chalmeshwar and Justice Bobde were hearing these matters, at that time the Attorney General, Mr. Mukul Rohatgi, he was being pushed into a bit of a corner where he was not able to show that the Aadhaar project was not infringing on our right to privacy. And given that they were pushed into this corner, their response was to essentially to use courtcraft to wiggle their way out of this difficult situation. So what did they do? They said that in the 1950s and 1960s there were 2 judgments, the Kharak Singh judgment and the P. Sharma judgment. And that those were judgments that were given by a 6-judge bench and an 8-judge bench. And those had not recognized the right to privacy as a fundamental right. Thereafter, there have been there have been many judgments since then, which have actually overruled those earlier ones, but also taken things forward. And they have said that, in fact, the Indian Constitution guarantees the right to privacy as a fundamental right. But Mr. Mukul Rohatgi had said that because the Kharak Singh and MP Sharma were given by a 6 and 8-judge bench, and all the other subsequent ones were given by a smaller bench, their status was actually questionable, and that a bench larger than those ones should deliberate on this matter and revisit a whole jurisprudence on this issue. So that's how the whole matter came to a 9-judge bench to examine whether MP Sharma and Kharak Singh were in fact overruled, and what is the status of all the other subsequent judgments which were upholding this right. So why is this a significant step forward? It is a significant step forward because now there can be no ambiguity about the existence of the right to privacy as a fundamental right. The government cannot find these wiggle out clauses anymore. So I think that's the first big advancement. I'm sure from the point of view of the legal fraternity, which I am actually not a part of, there are also the other issues that they are, I think, quite happy about. For instance, that Jabalpur, ADM Jabalpur case where Justice Chandrachud has apparently overturned his own father's. And I think that earlier one was viewed as a bit of a blot, and it was very close to the emergency, and it was in that context that judgment had been given. So that's another. I think that's something that other people are happy about. And the third one which even for me is a cause of excitement, is the observations that have been made about Section 377. And there's a very nice paragraph there where they say that overturning of the Delhi High Court judgment, striking down Section 377, which matters to the rights of the LGBTQ community, that has been questioned, and they've said that their sexuality is their own choice, and they should be protected for it. So I think those are three major things. I think also, when these hearings were going on, and then this Aadhaar discussion on Aadhaar has been going on, a lot of very well informed and articulate, and people who have quite an important voice in India in the public discussion and discourse have been maintaining, that nobody really cares about privacy in India, and the poor don't know that these elite people are going to court in their name. And I think that itself, this discussion that has happened is actually a very welcome discussion, even though some of the comments were very confused. And I really feel that those who maintain or held that view should read the relevant section of the judgment, because it so beautifully explains why exactly it is important for democracy to continue, and how you cannot think of one right as being above the other. They're all just intertwined, and in fact that is the history of our jurisprudence.
Right. So Ritika, tell me, the court in this judgment also, it read right to privacy as an integral part of right to life and declared it as a fundamental right. So, was right to privacy not a fundamental right before?
No. So, as I just explained, I think there are many cases, and I think the ones that they cite are Gobind, Rajagopal, and the PUCL case. Those cases, as well as this Menaka Gandhi and Cooper case, all of them, and there must be many more, I'm not a legal expert, all of these cases have recognized the right to privacy as a fundamental right. So it was there, but the government was actually going and putting a question mark over it, because there was that older, larger bench judgment. Right? So I think, okay, we lost a little bit of time, and the judiciary's time, especially with 9 judges devoted to these hearings, it is a big ask. And this is precisely what Mr. Mukul Rohatgi wanted. Is he wanted it to be kicked up to a larger bench, because they expected that then the bench would not be constituted, and then the matter would keep getting pushed further and further and further, and ultimately by that time Aadhaar would become fait accompli, and then everyone would be resigned to and lose interest in this battle.
So it would be right to say that the Supreme Court upheld the right to privacy as the fundamental right, rather than saying that now we have the fundamental right.
Absolutely, yes, totally. Yes, so, it's an important distinction. It is a right that we already had. Yeah. We were just asking for a confirmation.
So we've got the support of the judiciary.
That's right. And how?
Yeah, that's there. So as per the judgment, and I know that you've gone through some bits of the judgment. So could you please explain to us what is the scope of right to privacy? What the court had to say when it says that you have right to privacy? What's the scope, if there are any contours to it?
Right. So in the hearings, when the government's side was arguing, there was sometimes when they said it isn't a fundamental right, it's just a common law right. At other times they said, it may be a fundamental right, but you have to define and specify quite clearly. And the other side was never arguing that it's an absolute right in any case. And I think that's an ugly thing. Although an impression was created in the media that it was the petitioners who wanted an absolute right, with the government saying, no, put some reasonable restrictions. I think there is a fair understanding that there will be some reasonable restrictions, and what those restrictions should be will develop through jurisprudence over a period of time. But I think there were attempts from the government side to try and put particular definitions and to define it in a particular way. Now, thankfully, what the judgment has done is it has refused to go down that path.
Yeah.
They have said it is a fundamental right, It is inherent in these other rights, whether it's the right to equality or freedom of expression or right to life, etc. And that, of course, there will be some reasonable restriction, and I think it's important. One of the reasonable restrictions is in the interest of national security and crime and that kind of thing. And then later on in Justice Chandrachud's judgment, there is also a paragraph where, if you don't mind, I'll just read out a little bit.
Sure.
So he says, in a social welfare state, the government embarks about programs which provide to impoverished and marginalized sections of the society. It is vital. There is a vital state interest in ensuring scarce public resources are not dissipated by the diversion of resources. So, this, a lot of people are reading this as the paragraph that will open the door for using Aadhaar in these programs. But in fact, a lot of, in my own interest in the whole Aadhaar project and in this litigation, I am not a privacy expert, is because under UPA 2, when the Aadhaar program came, in 2009 and 10, it was being packaged as something that was going to get rid of corruption in these programs. It was going to prevent the dissipation of social welfare spending. So at that time, I examined the government's documents. UIDA still has those documents on their website, on the PDS and NRBG, on the Public Distribution System and the National Rural Employment Guarantee Act, and how Aadhaar might help. And in fact, if you read those documents and you know anything about corruption in these programs, you know that the solution that they have in mind is actually not going to cure the disease, because the solution is for a completely different problem and the disease is completely different. So I'll just give you one small example. This example, when people go to ration shops, they would be made to sign off or put their thumbprint in a register which would record 35 kilos of grain for them. But the dealer was giving them only 30 or 32, and this is the chori that was there. Yeah, this was the corruption in the program. And because people felt disempowered compared to the dealer, they would just sign off on it and say, better to take a little bit less this time than to risk not getting it next time at all. So now the solution that the UIDAI was bringing through Aadhaar was that we'll put point of sale machines and people will go and authenticate themselves at the time of purchasing their rations. So now what has happened, and we've seen this in Jharkhand and Rajasthan, when people go to the shop, they go and authenticate themselves, and the dealer enters 35 kilos. Instead of putting 35 kilos in a register, he puts it in a POS machine. And he continues to exercise the same power that he used to exercise before, and they're still getting 32 kilos. So, the corruption is quantity fraud, it's not identity fraud. And therefore, Aadhaar has very little role to play. So, when people read this paragraph and a similar paragraph elsewhere in the judgment, they feel that, this is how the government is going to push for Aadhaar in these programs. And I don't think, if the Supreme Court does as thorough a job at that time as it has done right now, then they will see the huge amount of evidence which is showing that Aadhaar is, if anything, causing harm to these programs and their implementation rather than enabling them.
So you've talked about this. You just spoke about Aadhaar at length, and you spoke about Section 377 of IPC as well. So this brings us. What I wanted to know is that what do you think are going to be the major implications? Although you've mentioned, if you can just elaborate upon the major implications that this particular judgment will have on the other cases and on the other litigations.
That's right. Yeah, so I think one big achievement you asked earlier, but from a very narrow, self-interested point of view, is that until 2015, before this got kicked up to a constitution bench, these Aadhaar hearings were proceeding, and we got very good interim orders which directed the government and told them that you could only use it in 2 programs, and then the list was expanded to 6, and you could only use it voluntarily. But these orders are being violated blatantly across the country. Yeah, so this was 2015, August and October, these orders came. Then in March or April 2016, the government passed an Aadhaar Act in a slightly dubious way also. Instead of allowing it to go to the Rajya Sabha, where they didn't have a majority, they had it passed through the money bill route. In fact, that's one of the challenges in the court as well, that, was it right to classify it as a money bill, and therefore. So that happened, and because of that, then the government started saying that all the earlier orders of the government don't really hold. But in fact, there's an order even after the passage of the Aadhaar Act, which is again from the West Bengal government had come to court and asked for a stay because they were making it compulsory for children's scholarships, children from minority groups. So all these orders that the Supreme Court had made, they are being violated left, right, and centre. The government has issued notifications making it compulsory not only in social welfare programs but for births, deaths, phones, mobile phones, everything basically. You can't breathe. Yeah, you just can't breathe basically. And if you don't do it, then you don't exist. Yeah, that's what it's come to. So, but in this time, the lawyers for the petitioners have been asking for these hearings to continue. But each time they were told, no, first you go to the Constitution bench, you get your right to privacy order, only then we'll allow the hearings to proceed. The PAN Aadhaar case was an exception and they were allowed to hear it. So now with this judgment having come, the good thing is that the Aadhaar hearings can start again. The original petitions, the contempt petitions, all of this, which is awaiting hearing in the court, will start again. So I think that's one big step forward. I mean, just the fact that the matter will be heard, can be heard again.
So we'll just continue the process now.
That's right. And the other important consequence is that we will go to these hearings from a much stronger position than before, armed with this rather useful judgment that has come yesterday. So I think from the point of view of those of us who were interested in the Aadhaar matter, these are two very important developments.
And what do you think Section 377 ICC, the case which is right now pending before the Supreme Court, how do you think that connection can be made on right to privacy judgment, and how it can be useful for Section 377?
Yes, I think what was really nice yesterday was that, of course, all the Aadhaar people were rejoicing. I mean, I think it's a judgment that should make every one of us happy, like from the most ordinary person to the most extraordinary person. But also the people who have been thinking of filing this review petition and reopening the Section Naz versus Kaushal case. There was quite a big buzz amongst them as well. So I think I have not been able to talk to them. I mean, I don't work on that issue myself, so I don't know what the thinking is there. But I also read that Justice Shah, who had written the original judgment, the Delhi High Court judgment, which had struck it down, even he has said today that after what we have seen in yesterday's judgment, the striking down of the Delhi High Court judgment by the Supreme Court is no longer tenable, is unlikely to be tenable. So I think there will be good news on that front as well.
So I mean, I think the judgment is going to have far-reaching consequences.
Yes, I think, I mean, it will be really, I really do feel like the existence of Section 377 and the death penalty, I mean, that really blots on any heart concerns democratic societies, right? So every step counts.
Great. So you were saying that every fundamental right, every right for that matter, comes with reasonable restrictions or some limitations, and you also gave us the example of national security. We've seen in the media everybody is hailing this judgment and speaking about right to privacy as a fundamental right. But we wanted to know if you can elaborate a bit upon what are the reasonable restrictions, how they can be read, and what kind of the scope of the reasonable restrictions will be.
See, I think a lot of the reasonable restrictions that have been listed in Justice Chandrachud's judgment, most of them are actually there's nothing new about them. Yeah, so this national security, crime, that kind of thing.
Right.
The new thing is this dissipation of social benefit expenditure, and I think that's very easy to establish that Aadhaar really doesn't have a role there. And then another area is, this is a recurring theme in the judgment as well as in the arguments that were made earlier, that, we are living in this age of technology, and, it's just all around us. And in this society, we're generating huge amounts of data. And so, in this data-fied society, what does the right to privacy mean? Right? So, and I think that is, of course, a very difficult question, but it's not a question that we are having to answer afresh. There is also, in this case, there is existing precedent, especially in Europe, I think there are pretty strong data protection laws and all of that. So, I think that discussion will also now start. The government has actually formed a committee under Justice Sri Krishna, and I guess they will deliberate on this matter about how much data can government collect from us, under what circumstances, and how can they use it?
Right.
Yeah, all of those things are difficult questions, because it's true that if the government wants to run a program, whether it's pensions or right to food, then they need to have a database which keeps track of who are the beneficiaries. But what the government was trying to do with Aadhaar was very pernicious, because these databases already did exist. It's not as if we're creating them afresh after Aadhaar came. The move towards computerizing administration of programs, which is actually what brings good governance to social welfare, that has been happening for the past decade or even more, right? But what the UIDAI wanted to do was to put this number, the Aadhaar number, into every single database in the country. Yeah. So today in my life, there are many data silos. One is my employment at IIT Delhi. Another is my rail travel. Another is my banking,
education.
Yeah. So there are all these data silos. My email account, my Facebook account. But who has access to it today? I am the only one who has access to it today, because I have the password for all these databases. So if you want to get like a full 360-degree view of my life, you're going to find it pretty difficult unless you hack into my accounts, right? But if you've put this Aadhaar number into every single database, then it becomes, first of all, I lose control over who has access to my information, right? Because so the loss of control by the creation of this mega centralized database, that's one problem. And then the other is the interlinking of it, right? So if you put the same number across all these data silos, you've created a bridge.
Right.
Yeah, and then anyone who has access to one number can creep along that bridge and get a full 360-degree view of my life.
Right.
So this is what people are calling mission creep. That this how it kind of becomes all
slowly creeps up on the life and takes it away.
So what Aadhaar was trying to do is to create like this electronic panopticon, where something that is able to keep an eye on you. And whether or not they keep an eye on you, the existence of the panopticon itself has the effect of curtailing my freedom. Yeah, so I was just trying to explain to someone, if you're on the road and even if you're doing everything correctly, you have your helmet on or you're wearing your seatbelt, you're within speed limits. The fact if you notice a traffic policeman there, you become slightly tense, you skip a heartbeat, you feel, even if you're not doing anything wrong. Similarly, if you know that you're being watched by a CCTV camera, you can't behave normally, right? I mean, you do feel, you behave slightly differently. So, and it's not as if someone has to actually watch the CCTV footage for you to behave normally. For you to alter your behavior. Just the existence of that CCTV is altering your behavior. So this is what this Aadhaar, when it's seeded into all these databases, that's exactly what it will do. Is you'll end up feeling a bit watched, and because you feel watched, even if you're not being watched, then you start curtailing your behavior a little bit, and that's an infringement of our freedom and privacy as well. And that's the bit that we want to stop.
Right. So, finally, what do you think? That is this judgment going to be a game changer?
Well,
in your assessment?
Yeah. Well, if we have respect for rule of law and if we listen to what the honorable judges have, their wise words actually, and I'm not saying this frivolously, then I think yes, it can be a game changer. What was slightly disappointing yesterday is that after the judgment came, various people from the government were saying this is our victory, and they've always said this is a fundamental right. And I was just blinking when I saw that. I was like, the judges are not going to run to the media and say, "Hey, these guys," but they were sitting there. There's a record of the submissions of the government on record in the Supreme Court, and they can make these kinds of statements, and maybe they'll even earn a lot of brownie points from their constituency. But that is the worry, right? That you can speak in 6 different tongues in the same instant. That I think that's so the judgment is there, and it is for us to use it and ensure that it gets well used. There's one really nice thing in the judgment, if you don't mind. So in the government was also arguing that this is an elitist concept. Yeah, it wasn't just the commentators outside, and it's been answered very well in the judgment. So they say, in our view, the submission that the right to privacy is an elitist construct which stands apart from the needs and aspirations of the large majority constituting the rest of society is unsustainable. This submission betrays a misunderstanding of the constitutional position. It must be realized that it is the right to question, the right to scrutinize, the right to dissent, which enables an informed citizenry to scrutinize the actions of government. Those who are governed and entitled to question those who govern about the discharge of their constitutional duties, including the provision of socio-economic benefits. The power to scrutinize and to reason enables the citizens of a democratic polity to make informed decisions on basic issues which govern their rights. The theory that civil and political rights are subservient to socio-economic rights has been urged in the past, and it has been categorically rejected in the course of constitutional adjudication in this court. So, yesterday, and I'll stop with this, yesterday on TV there was a debate, and the Vice Chancellor of NALSA, Faizan Mustafa, he was on it, and he said that this is really important because, suddenly those who scrutinize government actions, those who dissent, those who ask questions, uncomfortable questions, even comfortable questions sometimes, they've all been made out to be bad citizens. In fact, those are precisely the good citizens. And I think if anyone in government reads these passages from the judgment yesterday, then hopefully that this atmosphere that we're living in, this environment that we're living in, that will also hopefully change.